UT with legislature, and local authority referred to in subclause 1 of clause N of section 2 of the RTE.
It cannot be relevant here because this is only local authority defined.
Yes.
So that means any qualification from state with legislature or UT with legislature is applicable to all.
Within that state. For the government schools in that state.
The first one is central government. Second one is state government for the state government run schools. If you see the definition of school.
Just a minute, let it complete, otherwise you will not understand.
2N1, which defines a school.
2N1 is only for local authority.
No,
2N1 is something different.
2N1 is definition of school. So 2N1 says, if I can read that, school means any recognized school imparting elementary education and includes 1. A school established, owned or controlled by the appropriate government or a local authority. So all this assistant teacher recruitment that's happening, which is happening by the government, is for its own schools, which are covered by 2N1. Which could be owned by the state or by a local authority, but 2N1 is what we are looking at, not private school.
What is the meaning of this clause? If it is applicable in the same state, then there was no need for having this clause. Right? If you read the first clause that the central government, like CTET, is applicable pan-India,
Yes.
then the meaning of this means prima facie is by the state legislation or the UT legislature is applicable in the state legislature or UT legislature. It is equal.
So I'll just explain if I
This is what I understand.
Yes, I am. So break up. The way I understand this verse is this. 10 is in 3 parts. Now the first part. Yes, no, but I'm saying the way I understand this is a division of applicability based on territory. That's the way I see it. 10A is dealing with 2A1, which is a central government institution.
So he said B is not talking about central government, it is state only. Central is 1A.
2A1 and 2N1 are two completely different things. 2A1, if you just see 2A1.
Central government is 10A only.
Yes.
Then B is not talking about central government.
No, it's not. That's why.
So what is the import of 10B only? You just tell us that.
Just 10B. 10B is that if a state or a UT with the legislature, which is the appropriate government, makes here a TET exam is conducted by that state's TET would apply to all the government schools or local authority schools of that state.
From where you are taking that state? That state for that no provision was required.
No, I'm taking this only because this is
Provision was required.
I'm responding to your lordship's suggestion because these are guidelines.
Right. So for that no provision is required. That they have to issue guidelines for that.
But very often in guidelines they try to be as exhaustive as possible.
Not required at all.
So maybe it's superfluous, but this is the only. Let me just respond. No, there is a reason. The only interpretation which I am giving is the one which is consistent with the Act. If any other interpretation is taken, it renders section 23 to get me. That is not to. Please No, that is why the interpretation has to. Yes. Yes.
If we apply 10A,
Yes.
10A is applicable to subclause 1 and clause F of section 2.
Correct.
We have no concern.
Yes.
10A goes out.
Correct.
Come to 10B.
Yes.
Suppose we go to 10B.
Yes.
Then it says conducted by the state government on the duty
Yes.
with legislature's help.
Yes.
Alright. So now what we have to look into ET conducted by the state government
Yes.
or by the UT
Yes.
with legislature.
Yes.
It will apply to whom? Now from a school of the state government or
Of the. I'm sorry, but I'm saying the. If you just compare this with the above sentence, which says a state government, TET conducted by a state government shall apply to a school of the state government. So whichever state government conducts that, it is to them that it will apply. Otherwise, they don't have to do A and the separately. They would say A or any state government. They haven't used A. They haven't used any.
Right.
Yes.
So, but it is also using the local authority referred to
to subclause 1,
Yes.
clause n or so and so. 2
Yes.
and n, we see that
Yes.
2 and
1. Yes. A school.
1 is
A school established.
owned and controlled by the appropriate government or a local authority. Alright.
Yes.
Appropriate government or local authority.
Yes.
So here the state government means it indicates schools of the state government, and local authority means if we see this definition,
Yes.
then all local authority.
Yes.
So it falls within that. So it is in for 1.
Yes. Local authority is defined by laws in H.
In action defined.
Yes.
Alright.
Yes.
It is not at all relevant.
No.
Now to come to B.
Yes.
A school refer to subclause B.
Yes.
Subclause 2. Clause N.
Yes.
Please. Guided school receiving granted aid needs so and so as expenses of so and so
Yes.
to a RT Act of the so and so.
Yes. So government school or an aid?
That is it.
Yes.
So now what do you want to say now?
So what I want to say is this one, that two things emanate from guideline number 10. Two things. The first, that a central TET will apply only to the schools of the central government under 218. Second, that as far as state governments are concerned, when they conduct a TET, it applies to all the government schools and the aided schools within that state. That's why it uses the word the state.
So you are asking is,
Yes.
wherefore you are within that state.
From the words, I just TET conducted by a state government shall apply to a school of the state government. So it is of that state government.
You are giving this because they come with an argument. But giving their argument.
Their argument is based on the sentence after that, after the 1 and 2.
Yes.
That a school at 1 and 2 may also consider eligibility of a candidate who has obtained Ctet certificate awarded by another state or UT with legislature. So that is what their argument is based on. So because of this guideline, we are entitled therefore to permit those who are qualified. Yes. It's not continuous. It's very easy.
It's seen that.
Yes. And the next line after that, in case the state government UT with legislature decides not to conduct a TET, a school at 1 and 2 in that state UT would consider the Ctet conducted by the central government. So, this is what is being relied upon by them to argue that we are entitled therefore to allow as a qualification a non-Jharkhand TET or a CTET. This is their. So now, the problem with that argument of theirs appears to be that it would require to listing of section 23, which it is our submission is information. I want your lordship to also see the rules under the RTE, which provide for how relaxation can be granted. This is completely. This first sentence is what the High Court has relied on, so your lordship may mark that. That a school at 1 and 2 may also
You are
consider.
not disputing this situation, this CT can issue a guideline.
No, not issue.
Not disputing.
Not issue.
This guideline they have issued.
Yes.
While issuing this guideline, they have given one relaxation there. They
Yes.
have given this relaxation
Yes.
on which they are relying upon.
Yes.
And this is the relaxation. A school at 1 and 2
Yes.
may also consider eligibility of a candidate who has obtained TET certificate awarded by another state or UT with legislature.
Yes.
In case a state government UT with legislature decides not to conduct TET, a school at 1 and 2 in the state or UT would consider TET conducted by central government.
Second doesn't consider.
So this is for central government and first is for the other states.
Yes.
So they have from other states,
Yes.
they have been permitted under this clause. So suppose then who would permit it? A school at 1 and 2.
Yes. The school.
No. So
Yes.
that can be permitted.
But that requires this procedure follow. That's what I'm showing you, Lordship. If you see the RTE rules made with reference to section 23, I'm just showing you, Lordship. It's in the bare act itself. The Lordship takes a look. Rule 30A. Sorry, 17. Rule 17. I'm sorry. Rule 17.
So document says that the state did not exercise powers to
minimum qualifications.
Rules 17 and 18, Manoj. 17 says the central government shall within 1 month notify an academic authority for laying down minimum qualifications. That's been done. Now in 18, relaxation of minimum qualifications. The state government and the union territory shall, within 6 months from the commencement of the Act, estimate teacher requirement as per norms in the schedule for all schools, referred to in 2N. 2. Where state government or a UT does not have adequate institutions offering courses or training in teacher education, all persons possessing minimum qualifications as notified in sub-rule 2 of Rule 17 are not available in sufficient numbers in relation to the requirement of teachers estimated under sub-rule 1. The state government or the union territory shall request, their only job is requesting, within 1 year of the commencement of the Act, the central government for relaxation of the prescribed minimum qualification. 3. On receipt of the request referred to in sub-rule 2.
Whether it were at the commencement of the Act, because initially there was no institution, nothing.
That is correct. That is
Not
correct.
for subsequent period.
If that is so, then section 23(2).
That is exactly wrong.
No, yes. So if my argument would be that while this is at the commencement, it would also apply in every situation where at some point either you don't have enough TET qualified candidates, you can't give the children without any teachers. So then you need a relaxation for your state. So then you will write to them and say, please relax, I don't have enough TET qualified candidates. Or in a situation like, for example, some institutions are shut down, they may be because of nationalism or anything else. And then you may be in such a situation. So if we were to read it that strictly to say that it's only within 1 year, then you're leaving the states without any other alternative, but to conjure up mandate option. Yes. Yes.
Petitioners who were before the High Court.
Yes.
What were they doing before the High Court? What they were asking they did before the High Court?
Their prayers are at page 292 to 289 onwards. There are 4 prayers, I'll read them. A. Why no steps were taken?
Just page
289 of this. 289 bottom.
showing for the respondent. So why the steps are not being taken to conduct
the TEP since 2016 in spite of regular demands and protests, etc., etc. Then the second prayer verse is at 292. How they will redress the aspirations of a large number of candidates available who have acquired all of the requisite qualifications other than TET. Then press C. I'm reading on. Press C for directing respondent 2 to either conduct TET in the light of Jharkhand test, etc., which mandates the state authorities to conduct a TET every year, or to consider Ctet qualified candidates worthy for participating in the selection process of the teachers in the state. So there was an alternate prayer saying either you conduct it or allow Ctet eligibility.
So these are the Ctet persons.
Yes.
Ctet persons.
They don't have a Ctet. So they have a Ctet which permits them to apply for teacher positions in all central government institutions. So they have that. They therefore are asking for gated equivalence as well. We don't have the Ctet option. We have only our Jharkhand option. These are the prayers. Now, when this comes up before the High Court, at page 9 is where the judgment starts.
It's stand.
It's mentioned, yeah. This subject. If I can just see para 2, which is at the bottom of page 9. Bottom of page 9. The matter was heard by us, and in course of hearing on 25th July, our attention was drawn to clause 10 of the guidelines conducting TET. What I just read to you, Lordship.
So meaning when I see
Yes.
that this guideline applicability,
Yes.
then the later part of this B,
Yes.
later part of this B,
Yes. Later part of the speech.
in case the state government decides
Not to conduct. The school at 1 and 2 would consider the TET conducted by the central government. So that prayer is only about Ctet.
a school of 1 and 2, the
Yes.
state, in that state would consider the TET.
Correct. So clearly for this to apply, the state needs to take a stand that we are not going to conduct TET. Once the state says we won't conduct the TET, then obviously it's very fair for them to get the Ctet qualified candidates and ask them also to take part. State has not taken such a stand. That's not the state stand even today. On the contrary, the state has in its counter-affidavit said that we will be conducting the TET. They are conducting the TET.
Anyway,
Anyway.
not come to the
Yes. Now, if you just see para 4, this is the stand that they have taken. And
supplementary counter-affidavit.
yes, supplementary counter-affidavit. Just see extracted para 8. There.
Yes.
That it is stated and submitted that state of Jharkhand is intending to implement Ctet objectives in consonance with the geographical and regional needs, requirements such as various languages, tribal languages, culture and Hindi language speaking population within the state of Jharkhand. This is their event stand. So therefore, that guideline 10 won't kick in because they will conduct the exam and they will keep in mind culture, language, tribals, etc. etc. Now, para 6.
Yes.
Para 6. However, in course of hearing of these writ petitions today, Learned Advocate General appearing for the state would submit that he has received oral instructions that the state is willing to relax the criteria for eligibility as far as the candidates having Ctet examination certificate with a stipulation that at a future date they have to clear the state Tet examination and those persons should be the residents of Jharkhand. This is what we are agreed by because we don't believe the state could possibly relax. The state did not have this authority. The only exception is if the state took a decision saying we are not going to conduct the TET. The supplementary counter-affidavit makes it clear that they will. I can continue. Since the law provides that every year there should be a Tet examination, and for the last so many years there has been no examination for testing the eligibility of aspirants to be appointed as teachers, we are of the opinion that not only those candidates who have Ctet certificate and residents of Jharkhand, but also those residents of Jharkhand having other qualification and having state Tet examination certificate of any of the neighboring states shall also be given a chance to
So
appear.
they have taken both clauses
Yes,
of that applicable.
correct. Well, it was not even a prayer. The Lordship would notice the prayer was for Ctet in the alternative, not for any other state's qualification. They have widened it. Having other qualification and having state Tet examination certificate of any of the neighboring states should also be given a chance to appear in the examination with certain stipulations which you propose laid out in the following paragraphs. In view of the proposal made by the learned AG and also having considered the matter to a great extent perhaps, we hereby dispose of the writ petitions and the PIL directing the state government to conduct the TET examination every year henceforth. That's it. So, correct. So, para 8, we further, sorry. So,
Whether the High Court has considered this clause,
they only consider this.
in para 2. Para 2 it is considered.
The
Clause 10.
guideline clause. It's-
Considered.
That's one. Clause 10, nothing else.
Potential was done by clause to the guideline of PEG.
Yes,
So that is the subclause B.
correct,
So the school refers subclause 1 and 2.
correct.
Eligibility of the candidate who have obtained the TET certificate awarded by another state is also in case of that is quoted and
Correct. That's all quoted. That's
of such position, we are of the opinion the state government is genuinely creating a number of posts
yes.
for which the state TET examination is required to be conducted.
So, what they have not,
Not been held for the last almost 9 years.
yes,
Last examination was in 2016.
Yeah.
Taking into consideration the stop provision, therefore the advice of the council from the state
yes,
Whether they intend to allow these candidates who have TET examination. Okay.
Now, this has to be, if you just see now the directions at paras 8 and 9. These are what the errors creep in. Para 8 is page 12. We further direct that those residents of the state of Jakarta who are otherwise eligible to appear in the examination and hold a Ctet certificate or a certificate issued by neighboring states having resident of Jharkhand shall be allowed to appear in the ongoing process, which has already started, with a further stipulation that the state shall ensure that the examination, if not held within a year, is held at least within the next 3 years. So this is itself self-contradictory. If you are holding the exam as per the guidelines, there can't be Ctet. It's only when not holding the exam that you can have a Ctet. And the candidates who have participated in the selection process and have been appointed have to clear that Stet examination within a period of 3 years by giving one chance. They shall pass it within 3 years and in one first available chance. So this is the first direction. The second, we further stipulate that the state government shall not conduct the examination at least for next 3 months, so that the candidates should get some time to get ready.
May not be that.
May not be, but all this is completely unnecessary when you have 1 lakh candidates who are eligible and available.
Where is that 1 lakh candidates are there?
It's admitted in the counter of the state, Manoj. Let me page for you. Para page. Counter in the Supreme Court.
It was not there in the High Court.
There's a counter in the High Court, supplementary counter in the High Court.
Where is that? Not calculated.
Para page, no, numbers, one number.
Supplementary Supreme Court.
The numbers I understand are only in the Supreme Court counter-affidavit.
So where is that? Where you pleaded that?
That if you just see the Supreme Court counter,
No, where you have pleaded. You have to show somewhere you have
we
pleaded.
have come to the Supreme Court, no? So,
In your pleading, it has to be there, that only the counter will come in.
no.
You have to state something.
We came for the first time in the Supreme Court, so it's only from Supreme Court pleadings I can show you.
What is the question is being passed to you?
Yes, no?
In Supreme Court petition which you have filed,
Yes, sir. Yes.
you must have asserted here that how many candidates have appeared.
Page,
Therefore, adequate number of the candidates that were available to participate. Page possessing a TET from those are eligible.
page H, Manoj.
Page H.
H. Page H.
There is no reply given to the list of dates.
Where is the meeting?
Grounding from page 2 or 3.
So on that, if your lordships looks at the certificate that we annex at the end of every SLP, the certificate is an attestation by the advocate record in these courts that the SLP, synopsis, list of dates, all form one single composite. So when replies are filed, they're filed, but it's there in the grounds also. I'll show you both. I'll show you both.
Leave aside what certificates are given.
No, I'm-
Prior to that, we can show you hundreds of wrong, incorrect certificates.
Just see ground L in the SLP.
That I told you 2 or 3 pages there.
Yes.
Now see the counter, let us see the counter.
States counter. Page 13 of the states counter. That's counter on behalf of respondents 1 to 5.
Page 13.
1, 3. Para 8. In the peculiar facts and
Page 13.
page 13, yes, Manoj. So that counter, para 8.
Yes.
In the peculiar facts and circumstances of the present case, wherein the regular Ctet could not be conducted in the past few years due to COVID pandemic and other contingencies, and on one hand, there are enough members of Ctet qualified candidates within the state, approximately 1 lakh. Whereas on the other hand, a large number of Ctet qualified candidates and residents of state of Jharkhand who are aspiring to participate in the process of appointment. So here also they admit there's about 1 lakh of us. And they say there are enough numbers. So that they also believe there's satisfaction as far as quantity is concerned.
So now what is your argument finally?
So my arguments, the lordship can just pick up this note that sums up what my arguments are after the list of days, page 2. The first is that section 23 is mandatory. And those relaxations can only be made by the central government following the procedure that we've provided.
4.2.
Yes. 4.1 makes it clear that section 23 is mandatory. 4.2 talks about how relaxation can be only by the central government. And as your lordships have seen, that guidelines itself provides that Ctet is only for central government schools, not for anything else. The only thing in the guidelines which your lordship noticed is that they say if the state says we are not going to conduct the Ctet, then the question may arise of you borrowing and using Ctet qualified candidates. But that trigger, even as per the guidelines, admittedly is not there, because as we have shown you from the counter, their stand is we are conducting the exam. And again, in this counter just now, the same paragraph, they have said that we will be conducting, we couldn't conduct it because of COVID and other circumstances. So they have never taken a stand which fulfills that guideline 10 second part, which requires them to say that we will not conduct it, in which case, yes. So that even we are not saying that you can't if you are not conducting the exam. We are saying since you have said that you are conducting the exam, then you have to strictly go by Ctet.
Basically, 23(2) compliance is there.
Yes, 23(2) along with the guideline itself. Even if I am
Following the rules.
following throughout.
Following the rules.
Yes. Now, there's one couple of additional points. If you see 4.3 and 4.4 at page 3, we've given the page references. Service importance of Ctet cannot be overemphasized and has been accepted by the state. 4.3, page 3. Service rules provide that Ctet papers include tribal and regional languages. Jharkhand, being a tribal state with 32 scheduled tribes, requires regional language as a medium of communication with students. Jharkhand also has the third lowest literacy rate in India. Further, the state itself has admitted before the High Court that Ctet does not fulfill the needs of the state to the state regional language and local needs. This is at page 302. The Lordship will find it at paragraph 12. This is what they've said. It's part of the supplementary counter that they filed in the High Court. Sorry, it's main counter, not supplementary, main counter. Part of the main counter.
Alright.
Yes. And the other ground is on prejudice, Malaks, I've mentioned that. And finally, in the directions, if your lordship notice, they don't say that certificates of Ctet from any states, they say neighboring states. There's no rationale really behind any of this. They shouldn't have departed from what the requirements are, what the qualifications are when they admit that 1 lakh are available.
Relaxation is good, then that clause is good, that provision it is bad.
I'm grateful, that's all I.
Maybe in this meeting, when they have thought of, we don't know.
That's it. Left to the local. So there's a couple.
Yes, madam.
Please. Now, while you are on the counter filed by the state, which has been partly dealt with by the improved order, would you also kindly see just 2 paragraphs of the counter filed by the state, which is very relevant.
To counter type. In High Court.
Please come to page number 323 of the same paper to which Mr. Gopal had referred. 323. The reasons, because the High Court talks about them, it doesn't talk about what the state itself was concerned about. Please come to page 323, madam. That it is further stated that the central TET qualified candidate or a candidate qualifying TET by another state can only be considered for a state-run schools when particular state government has decided not to conduct its own TET. But it is most humbly stated that it is not the case that the state government had decided not to conduct the JTT, and in these circumstances, the state government is not bound to consider or a candidate qualifying TET by another state or UT as eligible qualifications. That CTET qualified candidates can remain eligible in a given contingency where the state government is not conducting TET But when this contingency does not exist, there is no occasion to make central TET candidates eligible or to allow those candidates who have obtained TET from semi-government or any other state TET. Now, in this scenario,
So your contention is
yes,
that the first counter-affidavit filed before the High Court.
this is second counter, supplementary counter.
This supplementary counter.
Yes, this is supplementary. Subsequent to the first.
Then supplementary counter says this.
Yes.
Then from where this concession has come?
This is oral milord. It is just the Advocate General says I oral concession. There is nothing in writing. Number
So
one.
that statement of Advocate General is.
Therefore they have taken it. Therefore they have taken it. Number two, milord. The entire writ petition, milord, entire writ petition is allegedly by, it's called as a PIL. In service law there is no PIL. In fact, all the petitioners are wanting to participate in this election. It's not a PIL in that sense. They are calling, they are an unregistered association. We do not know how many members are there. They came before the High Court, milord. The Honorable High Court ought to have at least seen all these provisions which my learned friend was now striving to point out, milord. What are the statutory sequence? What are the regulations to be applied? Whether it can be relaxed at this point of time, whether the contentions of the petitioner only for the player that please conduct JEP, which can be at a stage we are saying that in the upcoming selection, please consider it. Now please note the point, note the rules in existence on that day had only JTET. When they went to the writ court, there was no challenge to the rules in existence. They said the rules in existence when DG participated in the advertisement said only JTET. There is no challenge to that. In that scenario, whether the High Court would have rewritten the rule or the advertisement, your Lordship sir tell me not, you can't change the rules after the game has started. As simple as that. Whether the
Where are the rules?
yes, Lord. So my friend had pointed out 220.
234.
No, it started like that, but the other one quotes it.
228 at 234.
Yes. Please come to 240 and also 240, also 242. Yes, for primary. 240.
240.
Yeah, I first so 237 it starts. Thank you. But the peculiarity of the state is so much that they take so much into consideration, or they belong to various tribes, and therefore it's very important. The state had itself pointed out all those. 237. Para 3E, E is the middle of the page.
So you are is 248.
Which is
248.
Yes, Lord. It started at 228, Lord. Finally come to 234, which will say qualification. Right. Yes.
234.
Yes, sir. We'll start with qualification. 234 will start with qualification. Yes. Please come to middle of the page. Yes. Left side will be, intermediate teacher, education, what is that, all rules of mathematics, physics, etc. Coming to the 237 middle 3E. Candidates will be eligible for appointment as assistant teacher in the same subject group in which they have passed.
Subject is alright. We have to see
Over the case,
248.
240 comes in, but I made it.
You must read this last part. This.
Yes, that I wanted to read this 237 was the point which we were stressing that. Same subject in which they have passed the teacher eligibility test, and after passing the teacher eligibility test in the regional language, tribal language, notified for the district, will be appointment in that particular district.
No, the advertisement is district wide.
Yes.
Yes.
Is Applicability district wise?
Post somebody has done Santali, then they will be posted in that district. Yes. Advertisement.
Then we'll see, go back. Please first complete this.
Sorry, I counting at 240, at 240, state council, right by that. 240B and passed in JTET. The teacher eligibility test conducted for classes 1 to 5 and 6 to 8 by the government of Jharkhand under the guidelines formulated by NCTE. Yeah. Correct.
How about that?
242 also, it says 68 JT. Yes.
It is not 6 to 8.
Yes. Both are 1 to 5 and 6 to 8 are primary, upper primary. Please come to the advertisement. Yeah. There's one more, 2 lines in that advertisement itself, at 238 on top, Sorry, on the rules itself. On top, just 2 lines. 38. On top, first line, 238.
Yes.
It will be mandatory to have knowledge of local customs, language and environment. Yes.
They are basically, they say, residents of Jharkhand.
It is only English, they don't have all these languages.
It's a different thing.
Very well. No, that's good.
They have
Every child, in fact, they were Sharma,
They said residents of Jharkhand.
residence is fine, but they didn't pass, but he had passed in 16, waiting for the past 8 years. On different local customs and languages and tribal. My advertisement will be in the additional documents, not your lordships have seen it. There also at one, it is starting at 35, but relevant portion 51.
51.
51. Additional. The same volume which your lordships were seeing earlier also.
51.
But 51 will show district wise zone post for non-para.
Non-para, you are non-para.
Non-para, we are all non-para.
Even para is district.
Yes. Everybody is district wise only, but this is specially for non-para. Then come to 142.
So as per you, it is district wise.
This mellow.
And that during,
After this,
after qualifying the test, that time they may look into among
it's
this.
a district, it's post
Accordingly,
Yes, yes, no, rank wise. 142, your lordship will find the same advertisement. In pursuance of these rules, which contain JT, ET, your lordship saw it. Page 142, your lordship had seen.
And lately,
JT, right to government of Jharkhand is the advertisement also. This one, in this advertisement.
so the question is different. In JTET, and he is appearing, the person is appearing in JTET.
Yes.
So when he appears in the JTET, then what is the curriculum? That are they taking the test of language wise?
Particular language, they choose the language, particular tribal areas language, language. That's why they get an extra advantage.
So he will be eligible for appointment in another district.
He will not be, he will be chosen when he comes in the merit list according to his.
It comes the preference in the form and been prescribed.
The advertisement will show. Whose pension every person. Whose pension every person for this anyone other time as per secondary examination. Then we not see his gender social science and that's it. Mathematics.
Yes. Correction. We are asking for this syllabus on JTET.
Yes, sir. This is assistant teacher.
Yes.
Yes.
The question which was
Yeah.
was that for the purpose of the JTET, then to appear for the JTET,
Yes.
is it district wise, language wise, regional language wise,
We are instead of language wise, we don't have any reference of the rules here. Yeah, you
It's the
have
state's counter.
state counter.
State's counter in the Supreme Court at page 21 are the rules and the list of languages. Another page is 120, 21 and 31
Yeah.
of the counter of the state.
Yeah.
Page 21 is where it starts. Sorry.
Yes, please.
This is the notification.
Yes.
JTT test.
These are the TET rules for Jharkhand.
Yes.
It just comes to page 31.
31.
This is the district wise, this is a schedule. District wise list of tribal. Which is listed.
No,
That is there, where it
that
is
is fine.
level.
What we are asking Mr. Gopal and
Yes.
Nagi. What we are that's how this appointment would be in there. So where it is prescribed, number one, for JT curriculum, the person has to appear in this, and those persons as per have a preference under the rules in so and so, and option is required for the appointment in this regard.
So page 28 of this thing, just to go a little way back. 28. So now they give the pattern of the eligibility test at 28. After the table ends first. Just see G, not G, I.
Regional and tribal language.
Mentioned under language 2 rules will be as per schedule 1 of the rules. For appointment to the post of teacher, the candidate will have to take the examination in any one of the regional tribal languages allowed for the district applied. So in the schedule they give for each district what those languages are. And then,
No, district applied, that means you will be eligible only for that district.
Yes.
as per this, yes.
To please clarify this information,
Yes.
that I am going to complete today.
Very good.
We are saying,
Yes,
to clarify and clear the rules of that, you can find the rules.
right,
This is a rule for appointment, we'll say this one,
right,
so and. So for curriculum,
yes.
for that JT is concerned. Unlike for